Yes.
Yes, with bless your lordship. Lordship, I'd like to mention item 4. Lordship, I'm on behalf of my colleague, Mr. Musam Nongkamer. State is yet to receive instructions, so I may be allowed 3 weeks time.
Mr. So learned counsel appearing on behalf of Mr.
State respondents.
Learned government advocate
Yes.
with consent from the other side, press for listing the matter after
4.
4 weeks.
Up to 3 weeks.
3 weeks. 3 weeks.
After 3 weeks. So no, as the required instruction has not yet been received from the respondent authorities. Fair allowed.
Obliged. Lordship, I have same prayer for item 16 also.
16.
16, 1-6. Here I'm representing, myself is representing the state. Lordship, I'm Moa M. Chen, senior government advocate. I'm seeking 3 weeks time.
Mr. M. Insen, learned senior government advocate for the state respondent. You inform the other side? Any objection?
No, Lordship. Lordship, as per the office note dated 2/12/25, service upon respondent 4 is still awaited, Lordship.
Okay. With consent from the other side, press for listing the matter after
3 weeks.
after 3 weeks. Fair allowed. The learned counsel for the petitioner, however, submits that service upon respondent number 4 is still awaited.
Lordship.
What to do? You want to take fresh step?
Lordship, I may be allowed to take first step.
Okay. The learned counsel for the petitioner further submits that he may be allowed to take fresh step upon the respondent number 4. Fair allowed. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Much appreciated.
So, Lordship, we will allowed to mention item 11, Your Lordship. In this matter, Your Lordship, the state is yet to file counter. So I may be allowed 3 weeks time to file counter. Item 11.
Ms. Inahole, learned government advocate. Any objection?
No, Lordship. I'm appearing on behalf of Bentang Wapang, the leading counsel.
With consent from the other side, press for listing the matter after 4 weeks. 4 weeks. Fair allowed.
Bless you, Lordship. Your Lordship, in item 5, Your Lordship, here, my colleague AIME is representing the NSSP. So she's yet to file counter. So can we grant 2 weeks time to file counter in item 5?
Ms. So-and-so, learned counsel, appearing on behalf of Ms. So-and-so, learned counsel for the state respondents. Press for listing the matter after
3 weeks, Your Lordship.
3 weeks, so as to enable the state respondents to file the counter affidavit. Fair allowed.
Lordship, similar prayer on behalf of my colleague AIME. Item 12, Your Lordship. Here also 3 weeks to file counter.
Okay, same order.
And Your Lordship, in the hearing list, item 18. Item 18 and
Lordship, with regard to item 12, I may be allowed to withdraw, Lordship.
Item number 12.
Yes, Lordship. Also, this matter is pertaining to pending bills, Lordship, and I've received the payment, Lordship, if it may be closed, Lordship.
Okay. But someone has mentioned the matter. No?
Your Lordship, I was mentioning on behalf of my colleague, so.
Item number 12.
Yes, Lordship.
Okay,
If it's
okay.
withdrawal, then not.
Later on, Mr.
More Jamil.
Moazamir, learned counsel for the petitioner submits that the petitioner has received the pending bills, and as such, the grievance of the petitioner has already been addressed, and therefore he submits that the matter may be closed.
Lordship.
Accordingly, taking note of the submission of learned counsel for both the parties, this WPC number 184 of 2025 stands closed.
Lordship.
When Your Lordship, in a hearing list, item 18, Your Lordship,
Yes,
18, similar matter is fixed with the same government council on Tuesday, my lord.
coming Tuesday.
Yes, coming Tuesday. This is a covered matter, my lord.
Okay.
So
Okay.
it can kindly be listed.
As agreed by learned advocates of both the parties, this is at least the matter on Tuesday,
Yes, my lord. on Tuesday.
along with WBC number.
My lord, I'm not aware of the other case number,
Okay,
but
okay,
it has already been fixed on Tuesday, my lord.
okay, okay.
Item 25 as well, my lord. Same council, same issue.
25,
Yes,
okay,
my lord.
25,
Same government house.
same order.
Much obliged.
Lordship, I may be allowed to make a mention for item 14. This is an orders, my lord. The service about the newly implemented respondent number 3 is still awaited, my lord. So if it can kindly be listed after 4 weeks, my lord. I want to wait for some more time.
Mr. Santi Younger, learned counsel for the petitioner submits that service upon newly implemented respondent number
3, my lord.
3 is still awaited.
Yes, my lord.
You want to take fresh step or will await
my-
service report? Await.
Yes, we'll wait.
Accordingly, it is provided that recessal list the matter after 2 weeks,
4 weeks, my lord.
4 weeks, awaiting service report upon respondent number
3.
Respondent number 3. Miss, you are appearing?
No.
No, okay.
Lordship, there's an interim there. If you
Interim
can-
order pass earlier shall continue.
Deeply obliged.
Lordship, I beg to mention item number 8. I'm appearing on behalf of my colleague, Mr. Laknipom. He's for respondent number 2 and 3. He's indisposed today, so if your lordship would kindly list this matter after 3 weeks.
Any objection?
No, Lordship.
Okay. Miss so-and-so, learned counsel appearing on behalf of Mr.
Laknipom.
Learned counsel for the respondent number 2 and 3.
Yes, Lordship.
2 and 3 submits that the conducting counsel Mr. So-and-so is indisposed of NSS. See principal listing the matter after
3 weeks.
After 3 weeks, Mr. Fosiko Patel, learned counsel for the petitioner, submits that he has no objection. Accordingly, it is provided that recessal is the matter after 3 weeks.
Lordship, then interim.
Interim order pass earlier shall continue.
Highly obliged, my lord.
Please, Lordship. Lordship, I'd like to mention item number 19, Your Lordship, from the hearing list. Lordship, the leading counsel Pendang Wong is indisposed today, Your Lordship. So I pray if this matter can come up on 3rd of February.
Mr. Medovero, learned counsel appearing on behalf of Mr. Bendang
Wapang.
Wangbang, learned conducting counsel for the petitioner, submits that the conducting counsel is indisposed of and as such, he prays for listing the matter after
Oh, on 3rd of February.
3rd of February. You are appearing for
For the state, Lordship.
Miss, your good name?
Ichano.
Learned counsel for the state respondents present.
Much obliged, Lordship.
Mr. Lordship. Lordship, I beg to mention item number 3. On behalf of Excha. Lordship, we kindly grant 3 weeks time to file affidavit.
No, please.
Miss so-and-so, learned counsel appearing on behalf of Miss Sang, learned government advocate. Price for listing the matter after
3 weeks.
3 weeks. As the learned government advocate is indisposed of or is
Yet to file, Lordship.
Yet
Yet
to?
to file affidavit.
government advocate has not yet filed the affidavit in opposition. Mr. Walling, learned counsel for the petitioner, submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recessal list the matter after 3 weeks.
Lordship.
Obliged.
Lordship, item number 6. Here I get to receive instructions, so if 3 weeks time is then granted to me, Lordship.
Ms. So-and-so, learned government advocate, with consent from the other side, submits that she has not received any instruction from the state respondents and she prays for listing the matter after
3 weeks.
3 weeks. They are allowed.
Lordship, I would also like to beg to mention item number 9. Here I get to receive instructions, so if 4 weeks time is then granted to me to receive instructions, so well, to file affidavit.
Yes.
No.
Ms. So-and-so, learned government advocate, With consent from the other side, submits that she has not received the instruction from the respondent authorities and press for listing the matter after 4 weeks. Bear allowed.
Lordship, item number 10, on behalf of Abidoli.
On behalf of?
AIB,
Okay.
3 weeks time actually granted to me, Lordship.
Any objection?
Lordship, let it be the last opportunity, Lordship.
Okay. Ms. So-and-so, learned counsel. No, learned government advocate. Submits that she has not received the instruction and press for listing the matter after
3 weeks, Lordship.
3 weeks. The learned counsel for the petitioner, however, submits that last opportunity may be granted to the learned government advocate to file the counter affidavit. Accordingly, taking note of the submission of learned counsel for the petitioner, the learned government advocate is granted last opportunity to file the affidavit in opposition. In the event of failing to file the affidavit in opposition before the next fixed date, the court will proceed to hear and dispose of the matter without the affidavit of the state respondents.
Lordship, item number 13 as well, on behalf of Tipa. He's yet to receive instructions, so it 3 weeks time actually granted to me, Lordship.
Similar order? No objection?
No objection.
Okay.
I pledge.
Mr. Lordship, on behalf of the council for the petitioner, I beg to mention item number 22, supplementary causes.
Item number
23.
22.
Yes. Lordship, the senior counsel was in disposal to not come up after 2 weeks.
Who is the conducting counsel?
Sasisole.
Ms. So-and-so, learned counsel appearing on behalf of Mr. So-and-so. Learned conducting counsel for the petitioner with consent from the other side, press for listing the matter. After
2 weeks.
2 weeks, as the conducting counsel is indisposed of, where allowed, recess and list the matter after 2 weeks.
May I please, Lordship? Lordship, I picked the motion, item number 7, Your Lordship.
Item number 7. Yeah.
And for the private respondent, I'm yet to file my affidavit of opposition. 3 weeks time may be granted.
You are for respondent number?
4, Your Lordship.
Respondent number 4. Mr. Your name, please? Learned counsel for the respondent number 4 submits that he has not, no, the respondent number 4 has not yet filed the affidavit in opposition. And he press for listing the matter after
3 weeks.
3 weeks. Mr. Medovero, learned counsel for the petitioner, submits that he has no objection. Accordingly, it is provided that recess shall list the matter after 4 weeks. Or
3 weeks.
3 weeks, okay, after 3 weeks.
Much obliged.
May I please, Your Lordship? Lordship, I'd like to mention item number 21. Lordship, here the leading counsel is indisposed, so kindly let this matter come up after 3 weeks.
Miss, your name, please?
Grace Namgi
Learned counsel appearing on behalf of Mr.
and Wongkumar.
and Langkumar, learned conducting counsel for the petitioner. Any objection?
No objection.
With consent from the other side, press for listing the matter after
3 weeks, Lordship.
3 weeks, as the conducting counsel is indisposed of. Where allowed, recess shall list the matter after 3 weeks.
Yeah, please, Your Lordship.
Yes.
Lordship, I beg to mention hearing item number 24. Your Lordship, here the state council is in disposal. Can you let the matter come up after 2 weeks?
Who is indisposed of?
State council,
State counsel.
Your Lordship.
You are not for the petitioner.
Your Lordship, I've taken consent from him.
Okay. You are for the petitioner.
Yes, I'm for petitioner.
Miss, your name, please?
Ace Chilam.
Learned counsel appearing. Learned counsel for the petitioner with consent from the other side, press for listing the matter after
2 weeks, Your Lordship.
2 weeks. Fair allowed.
By please, Your Lordship. I beg to mention item number 23. I'm appearing on
22 already mentioned.
23,
20.
item 23.
Okay.
I'm appearing on behalf of counsel for petitioner. The counsel for petitioner is in this so currently adjourned matter for 3 weeks.
Mr. So-and-so, learned counsel appearing on behalf of the conducting council, Mr.
Toshi Temjin.
Tosi Temzen Pongdar, learned conducting counsel for the petitioner with consent from the other side, press for listing the matter after
3 weeks.
3 weeks. Fair allowed. Press shall list the matter after 3 weeks.
Obliged.
From the supplementary cost list for motion, item number 20.
May I please, Lordship?
Yes.
Here the petitioner is aggrieved as his standing building and developed property was badly damaged during the construction of the two-lane road construction from National Highway 202K Akwego to Avangko section in Belur district. He have given his representation complaint dated 4th May 2025 to the Deputy Commissioner to carry out verification of his damaged residence at Weziho town. But till that, before filing, there was no response or nor his prayer was considered. Therefore, my lord, I have a limited prayer to direct respondent number 7, Deputy Commissioner Mallory, to carry out spot verification and, if necessary, bring out the assessment report of the damaged properties.
No, instead of no, can we dispose of this petition by directing the respondent authority to dispose of your representation?
Yes.
Okay.
I am referring for respondent 1, 5, 6, 7, and 8. There are also the NHI DCL. Oh, yes, who has been made as party respondent 2 and 3. 2, 3, and 4. Lordship, since the prayer of the petitioner is limited only to the extent of disposing of the representation submitted by him on dated 4/5 to 2025, I have no objection to the prayers made. However, Your Lordship, some sufficient time may be granted to the respondents to conduct the verifications along with not only the respondent number 7 and 8, but along with the officials of the respondent number 3 and the site engineers, if they have, of the firm that has been doing the construction, Your Lordship. If that direction can be issued, Your Lordship.
Yes.
Yes, my lord.
Okay. Heard, Mr.
I agree to all, my lord.
Learned counsel for the petitioner and also heard Mr.
And Angami, Your Lordship.
N. Angami, learned
Senior government
advocate for the respondent number
1, 5, 6, 7, and 8.
1, 5, 6, 7, and 8. In this petition under Article 226 of the Constitution of India, the petitioner, namely K. Thasu of Waziho Town, Mallory, has prayed for issuing direction to the respondent authorities to conduct spot verification and bring out the assessment report for quantification of the properties of the petitioner for assessment of the damages. Quantification of property or the damage?
of the compensation damage.
compensation. For assessment of the damage. Assessment of the damage and also for quantification of the damages which the petitioner is entitled to. Learned
Lordship, because since today, as of today, we don't know whether any damage has been done or not. So as has been alleged by, as has been alleged by the petitioner in his representation dated 4/5/2025. If that can be settled, madam.
Yes, this is the pair made in the writ petition.
Correct.
I am reproducing only the pair.
Lordship.
The learned counsel for the petitioner submits that the petitioner owned a residential building along the highway, particularly at main town Waziho, which he has built on his own expenses by developing the land and by constructing an RCC building and also made a half pasa type. The learned counsel for the petitioner further submits that after construction of the two-lane began, the by the respondent authorities, the cement plasters began to fall due to heavy machineries being used by the authorities in construction of the two-lane project. The learned counsel for the petitioner further submits that the petitioner has filed one representation copy of which is annexed with the petition as annexure number 3, addressing the Deputy Commissioner Mallory. But on 4th of May 2025, for assessment of the damages caused to his residential building, but the same failed to evoke any response, and being aggrieved, the petitioner approached this court by filing the present petition. The learned counsel for the petitioner further submits that this writ petition may be disposed of by directing the respondent authorities to dispose of the representation dated 4/5/2025 Mr. Angami, learned senior government advocate for the respondent number 1, 5,
6, 7, and 8.
6, and 7 submits that since the pair is limited, he has no objection in the event of directing the respondent authorities to dispose of the representation after conducting an inquiry in presence of the respondent number 3.
Yes, Lordship.
Respondent number 3.
And along with the site engineers of the Maya Shield Construction Private Limited.
Along with the site engineers of Mayasri
Shield Construction Private Limited.
Mayasri Construction Private Limited. Whether that company is a party here?
Your Lordship, these are the firm, according to the petitioner, who is constructing the national highway.
But they are not a party here.
Lordship, I think these
No, not implicated as party.
Because the construction is being done by them according to the petitioner in the environment bait, Your Lordship, at para 2. Para 2, Your Lordship, page 6.
Okay, along with the site engineers of Mayasri Construction, Mayasil Construction, JSP Private Limited, as the said company has been carrying out the construction work.
Correct.
Construction work. But having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the annexure 3, the representation filed by the petitioner to the Deputy Commissioner Mallory. Taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to dispose of this writ petition by directing the Deputy Commissioner Mallory, the respondent number
7.
To dispose of the representation dated 4th of May 2025 filed by the petitioner. After making necessary verification of the of the residential building of the petitioner in presence of the respondent number 3, and also Mayasel, also in presence of the site engineers of Mayasel Construction JPS Project Private Limited, within a period of
3 months.
within a period, yes, 3 months.
3 months, 2 months.
Lordship, a reasonable period may be given, Your Lordship.
Okay,
2 months. 2 months. 2 months will be sufficient.
Lordship, to be on the safer side, Your Lordship, if 3 months can be granted, kindly, Your Lordship.
Then, my lord, sometimes we don't have the information of the contractors, of the present contractor. So if my lord may kindly add, if discretion may be given to the deputy commissioner to request the concerned contracting firm for spot verification. If there is
Yes,
sense
in
of-
presence of, already we have directed, in presence of the
Concern.
site engineers of the Mayasil Construction JSP Private Limited. And the aforementioned exercise has to be carried out within a period of 3 months.
3 months.
Within a period of 3 months. In terms of this writ petition instance, the disposal of this motion itself.
I'm deeply obliged.
Clear back, my lord.
For admission, item number 1.
Please, Lordship.
Yes.
Lordship, I may bring on behalf of H. Bora, Lordship.
Hmm.
Lordship, I have instruction to withdraw the case, Lordship, with liberty to file a fresh, Lordship.
Withdraw the case.
Lordship.
Or Mr. Madovero, learned counsel, appearing on behalf of Mr.
H. Bora.
H. Borwa, learned conducting counsel for the petitioner, and also heard Mr.
LD Samdan,
learned
additional AG,
additional AG,
for state respondent number 1 to 4.
respondent number 1 to 4, and you,
P. Mumbeni Izum on behalf of my senior Joshua Shiki for respondent number 5.
respondent number 5. Mr. Madovero, learned counsel, appearing on behalf of Mr. H. Borwa, learned conducting counsel for the petitioner, submits that the submits that he has the instruction to withdraw this petition with a liberty to approach this court again by filing appropriate petition. Accordingly, taking note of the submission of Mr. Madovero, learned counsel, appearing on behalf of Mr. H. Borwa, learned conducting counsel for the petitioner, the petitioner is allowed to withdraw this petition. However, Liberty will remain with him to approach this court again by filing appropriate petition.
Much approved.
For admission, item number 2.
Yeah, please, Your Lordship.
Yes.
Lordship, we are supposed to file our reply to the additional affidavit filed by the respondents.
Mm.
But because of the bereavement, we could not file. Kindly grant us 3 weeks time to file.
Okay, heard, Mr.
CD room, so much.
Learned counsel for the petitioner and Miss
For the state lordship, for respondent 1 to 4.
I'm for respondent number 5.
respondent number 124 and Mr.
Braga.
Learned counsel for the respondent number 5. The learned counsel for the petitioner submits that due to bereavement, he could not file the reply to the affidavit in opposition filed by the respondent authorities and he pressed for additional affidavit filed by the respondent authorities. And as such, he pressed for listing the matter after
3 weeks.
3 weeks, so as to enable him to file a reply to the additional affidavit filed by the respondent authorities. We are allowed to list the matter after 3 weeks.
Your Lordship.
For orders, item number 15.
None appears for the petitioner.
Can you grant 3 weeks time to file affidavit?
None appears for the petitioner on call. However, Ms. So-and-so, learned government advocate present for the state respondent. The learned government advocate prays for granting her 3 weeks time to file reply to the to file counter affidavit. Counter affidavit. Fair allowed. It appears that the petitioner remain absent on 12/12/2025 also. In the event of subsequent non-representation of the petitioner on next date, appropriate order shall follow.
I pledge.
For hearing, item number 17.
The petitioner is one of the landowner, where the establishment of the legal metrology and consumer protection office of Mokokchung district established. How it happens is that the said land belongs to 3 plots. And there is an agreement way back in 1972. 72, yes. That the landowner will be given the privileges. Annexure 1, page 25. May I read out, madam? 25A is the type copy. Memorandum of agreement made on this the 18th of December 1902 between Sri Nangsangmaran, care of Mayapur, such and such, by occupation cultivate at present resident of such and such, that referred to as owner, which expressions shall mean the descendants. The government which expression shall mean and include his successor, that is the assigns of the other part. So it was between the landowner and the government. Whereas the immovable property in the structure in particulars where up are set out in the CTO, whereunder written after the said property has been transferred to the government under this agreement and the 18th of December 1972, taken possession of by or on behalf of the or under the authority of the government. As the owner has voluntarily transferred the said property to the government and stated to the government that the owner alone with entitled to all compensation payable in respect of the said property, and no other person has any right to such compensation in any part in whereas the owner in the government have mutually agreed to settle the amount of compensation payable by the government to the owners in connection with the said transfer in the manner hereinafter appearing. Now therefore agreed by and between the parties as follows. The government shall be and the owner shall accept and receive a sum of rupees 21,800 at the rate of rupees 2,000 per acre money. In rupees 21,800 only as compensation in full settlement of the compensation for the said property. The owner shall not claim or be entitled to any other compensation whatsoever in connection with the said transfer. Then the terms comes 3. The government have given all the facilities to the landowner. What? Both such as natural, rail staff, 2. Contract work to be allotted without inviting tender. Without the knowledge of the landowner, any contract work must not be given to outside. Then 26B. It is hereinafter transpired that the owner is not entitled to or exclusively entitled to the compensation payable in respect of the said property, such and such, to be any other person, the owner shall refund to the government the compensation paid for such paragraph as the owner is not entitled to in shall otherwise indemnify the government against the loss or damage suffered by the government for reason of fault or defect in is entitled as represented by the owner without the prejudice to any other remedies for the enforcement of such refund and indemnify the government may forever the sum payable by way of refund and indemnify as errors of the land revenue. Above referred to total area of 10.90 acres. It is in the prime land of Mokso town. The boundaries are given. Then what happened is that page 27. One whose Jupiter come, watchmen come, Jupiter they call it. This is 4th April 2023. In terms of section such and such, which comes into effect from such and such, Sri to Siwabang, that is the retired person. Watchmen come, such and such, serving under the establishment of, my lord, this is important, where controller of legal metrology in consumer protection, Nakuan Kohima is hereby released from service on completion of such and such 35 years of service with effect from 31/8/2023. Name to show up watchman come such and such. Office in place of posting. Office of the Assistant Controller of Legal Metrology in Consumer Protection. Mogokchong. The vacancy arose in that particular establishment, not in other place. That is what I am trying to see. Then page 28. To the additional, that is head of the department. Application for the post of watchman come together as a rightful landowner candidate. That is the application. On the body of the application, it is the advisor, that is the MLA of the concerned area. Another advisor, such and such, as Assembly Constituency MLA, may I request the Honorable Advisor kindly consider for appointment to the vacant post. He is also a landowner of the office where it is located, Melo. That is dated 15/9/23. Yes, 15/9. Then the land next 29 page. Because the land being belong to 3 subclans. They have their own office of the younger landowner. Younger means the concerned group. If it is one clan only, that is a different thing. But it being a group of 3 subclans, to whom it may concern, this is to certify that such and such, that is the petitioner, bona fide citizen of such and such, belonging to younger 3 subclans. He is applying for the post of watchman come together under the establishment of a LMCB office Mogoktu against the vacancy caused by such and such and determined after such and such. It is worthwhile to mention that the land of Assistant Controller of Legal Metrology and Consumer Protection Mogoktu, Nagaland has been donated by Younger in view of ministerial strife in contract works arising in the office. However, it is reiterated and placed in record that our 3 subclan is concerned. His subclan has not availed any job opportunity. Malo, that is the 3 subclan. They are stating that only this particular subclan have not availed any job opportunity till date. The land has also been donated by a subclan. Now, Sri such a legitimate only member from Younger is applying for the post stated above stated post, hence strongly recommends his case for consideration on priority. So the 3 subclan representative 1, 2, 3, Malo, dated 5/9/23 and duly forwarded by, this is dated 4/9/23 and forwarded by whom? This is a statutory body. Order for necessary action 5/9/23, Chairman, Kansas Village Council. So as far as the land of the village is concerned, it is under the knowledge and control of the village council of the concerned. Then proposal was sent by page 30 to the secretary to the government of Nagaland. This is from the head of the department. Proposal for appointment to the post of watchman, Kam Chokita, Malo. Madam, with reference to the website, the subject, I have the honor to forward here which application received for the post of watchman come together. Madam, this is important. Where under the office of the Assistant Controller of Legal Metrology and Consumer Protection, Bogok Tungmano. Against the vacancy set in such. So, applicant following candidates, one is Taku Sanga, that is respondent number 9 and 10. Why 9 and 10? It is the same person. Recommended by the Honorable Speaker, Nagaland Legislative Assembly. Why? Because I was also recommended by the MLA of the concerned constituency to no objection to that effect. Sri Monson, that is the petitioner recommended by Kensha Village Council. So duly constituted statutory body. Three, Sri such and such, recommended by the Honorable Minister, such and such. Then it appears that why these other two were forwarded this by their own application. Respondent 910, page 31. Nowhere it claims about any right toward the state. Suppose the question of learning is not clear. So also page 32, there is one applicant forward. So after this, what happened is this, my lord. Page 33. So this is from the government level of Legal Metrology and Consumer Protection Department, dated 21st September 2023. Why? The question is portrait. So it is DC Mohokto, that is the district concerned, subject verification of NOC. Sir, I am directed to forward here with the copy of industry leaders and such, received from the office of the younger, that is landowner, page 29. Which was submitted by Sri petitioner seeking appointment to the post of watchman come together in the vacancy caused due to such and such in the office of such and such Mokok Chung, who retired on such and such. In view of the above, it is requested to verify the documents in NOC from the younger landowner Kim Yuar Kensan Mokok Chung dated 4/9/2023 as under for further necessary action. One is whether the landowner's claim is genuine. If genuine, whether there is any agreement made between the landowners and the government. Two, whether any compensation was made for the land donated. Three, whether the landowners avail employment to grade 4 posts. That is from the department government level to the district deputy commissioner of the concerned office. Then, when the verification was so, the village council, earlier it was just forward. So when the village authority was asked about the land ownership, So dated 27/9/2023. They call it no objection certificate, but one fact remains that who is the unknown? Certified that is the petitioner, such and such, bona fide citizen of Kansas Village, Mo from Nagaland, he is the rightful landowner of the Assistant Controller, LMCB, Mohokro. It is iterated in place in record that the land was donated by Hangar Tree subclan. However, his subclan has not availed any job opportunity till date. This may be true. The land has also been donated by his subclan through Memorandum of Agreement dated 18 December 1972, my lord. That is Annexure 1, between the landowner and the government of Nagal. Now, Seri petitioner, a legitimate only member from the landowner, is applying for the post of watchman contributor vacated by such and such. The village council of Kansas Village has no objection for appointment of Seri petitioner to the vacated post as landowner candidate, my lord. Then, verification report. My lord, you are aware about the passes in Nagaland. You work as interpreter within the administration. Through verification report, page 35, the undersigned, along with the passes, that is the interpreter of Ong Pangkong, conducted the verification on 25th September 2023 regarding the verification of petitioner of Kansas Village seeking appointment to the post of watchman come together in the vacancy goes due to retirement of such and such. Watchmen come together in the office of the, my lord, why I am impressing upon your worship is where the vacancy, that is Assistant Controller, Legal Metrology and Consumer Protection Motion, who retired on 31st, such and such. On verification, the case was found to be genuine to the best of my knowledge. This is for information and necessary action. So that is the administration and the interpreter under the administration of the concerned Ong Pangkong is a range name where the administration, that is the extra assistant commissioner headquarters. So hit the basi Ong Pangkong Mokokcho, dated 27/9/2023.
No, you see, this letter was written by the Deputy Secretary to the Government of Nagaland.
My lord.
To the Deputy Commissioner Mukoksang.
My lord.
For verification of the NOC.
Yes.
Whether the Deputy Commissioner has submitted any report.
My lord. My lord.
Pursuant to this letter.
Yes, that I'll come to. Then,
where is that report?
Page 36, my lord.
Page 36.
Yes. That is the extra assistant commissioner of that particular area. After that, there is a report. To that effect, I understand your lordship.
No, page number 36 is the report submitted by the extra assistant
commissioner of that particular, yes.
to the Deputy Commissioner.
My lord.
No, whether the Deputy Commissioner has submitted any report.
My lord.
Is it page number 37?
My lord. May I read up, ma'am?
Yes.
Verification of NOC regarding, sir, on the subject cited above with reference to your office letter number regarding verification documents. the documents and NOC for payment to the bonds of watchmen come together submitted by the younger landowner in Yuwar Kansap Mokong. In this regard, I am directed to forward here with the verification report submitted by the extra assistant commissioner Hong Pangong in the head the Pasi Hong Pangong for further necessary action. So it is a forwarding of page 35 in 36. So I may be allowed to read out 36 also, man. To the DC. Subject appointment to the post of watchman come together in the office of the assistant controller legal metrology in consumer protection Mohokchung in the matters there. Sir, inviting a refers to the subject side as directed by the higher authority. It is my honor to submit here with the verification report as required by the legal science search by dated 21 September 2023. Upon verification, it has been learned that the learner provided by the office of the assistant controller legal metrology and consumer protection Mohokchung originally belonged to 3 sub-clans, namely Takachujang, Mokok Sangba, and Nikan. So that is the 2 sub-clan who owns the land. This land was purchased by the government in the year 1972, and accordingly an agreement was signed with the landowner, which is endorsed for your reference. It has also been verified that the applicant Mongsner is a genuine landowner belonging to the Nikan sub-clan, my lord. He has been recommended by the 3 sub-clan as well as village council includes the following points are therefore presented for your kind information. 1. The government, as per the agreement in 72, has promised both sides ministerial strat to the concerned landowner. Therefore, the landowner claimed by Mr. Such is genuine. An amount of 21,000 was given as compensation amount. 3. Members of the 2 of the 3 subclans, Takachujang and Mohok Sangba, have already been appointed under the office concerned. However, Nikan clan is yet to avail that benefit. My lord. Petitioner belongs to Nikan subclan. So this is what the page 37 is forwarded to the government. My lord.
So it appears that you have received a sum of rupees 21,800 as compensation.
Yes. Way back in 72. But with an agreement that the job opportunity as well as contract will be given to the landowners. That is the specific offer and acceptance in 1972. So after all this exercise, as per the direction of the department, by the administration, what happened? Page 38, which is the review later. This is head of the head of the department. Approval for appointment of the post of watchman come together in the office of the assistant controller in legal metrology, consumer protection, and speak up science. I am directed to refer to your later science search and the subject cited above will convey the approval of the government for appointment of respondent 910 to the post of watchman come together where in the office of the assistant controller legal metrology in consumer protection Mohokchung. So a specific approval by the government is in the office of the assistant controller legal metrology in consumer protection Mohokchung. Mango. December 2023, dated. Then what happened? Page 39. December 13 December approval. Where? Mokokchung office. Consequent approval by government mentioned hereby appointed watchman come Jupiter in the office of the Controller of Legal Metrology and Consumer Protection Nakalan Kohima in pay level of science admissible under the rules enforced from time to time with effect from taking over charge. Respondent 19. The appointee shall be. So that is what I'm trying to point out. The illegal action. Because the appointment is directly in the office of the Assistant Legal Metrology and Consumer Protection, Mokokchung. If given this appointment, yes, in the office of the, that is the directorate. Then, again, page 40, which is also impure. What happened? They have done directly the approval is for that particular office. Page 39 is not in that area. Then, page 40, interesting.
The post has arisen at Mukoksan
Yes, Madhav, that is what
in the
I
office
think.
of the legal metrology.
Yes, in the approval is
But-
specifically in the office of the Assistant Controller in Legal Metrology and Consumer Protection, Mokokchung, page 38. Approval is specific in the office. Then page 40, how they acted. Consequent upon, this is same dated, page 39. In 40, it is same dated. Such and such, in the interest of public service, respondent 910 is hereby appointed to the post of watchman count together in the office of the Controller of Legal Metrology and Consumer Protection, Nakalan Kohima. And what happened? Posted in the office of the Assistant Controller of Legal Metrology and Consumer Protection, Timabo. So what I'm trying to impress upon your lordship is that as per the department direction, the whole process of verification about the petition have been carried out. When it was sent to the government, they given approval for a different person without thinking about the whole process of verification. Approval, apart from being illegal, without thinking about the verification of the respondent number 8, the person 1. That is the Deputy Commissioner in the present petition. Affidavit, they have not filed for respondent number 8. So whatever verification and info given by respondent number 8, nobody is denied. Because the government side, they file for respondent 1 to 7. That is the department level, up to the assistant legal controller, Mokokchung. In this verification has been done by the administration, that is respondent number 3. As far as my claim on the basis of the landowner in the verification by the administration is not disputed by anybody. Then, my lord, there is a procedure laid down by the government, page 41. PNER, 3rd March 2022, my lord. Your lordship, may kindly bear with
No,
me.
you see, there's a respondent number 9 and 10.
My lord,
They're the same person.
they are the same person.
Same.
Yes. Once appointed by the same order, 14 December.
Mm.
And again transferred to another establishment. The appointment is not in the place where approval is given. So it becomes 2 respondents of the same person, respondent 9 and 10. If they have acted only as per the approval, even though illegal, it will be in the assistant controller more often. So I am compelled
So, on what basis she has been selected?
My lord, there was no selection. She is not a landowner. There is an agreement which is not been considered.
Mm.
Over and above, the department itself has started that verification.
Mm.
When everything was found to be genuine,
Mm.
they have given approval for a different person. That is 9 in 10.
Mm.
My lord, if your lordship may kindly consider about the land holding system in Nepal. It is not like the rest of the country.
Mm.
The land belongs to the individual or to the community.
Mm.
It's not a government. So whenever there is establishment to be, the government wants to negotiate like any other individual.
Mm.
I'll give this, you give me this.
Mm.
So that is a particular provision which page 16 of my writ petition.
So, is there any procedure of appointing in appointment of grade 4 staffs?
Yes. Yes. That is what I'm trying to point out, my lord.
Yes.
First, what I'm trying to impress upon your lordship is about the land holding system.
No, that's all right.
If you are
Here, the individual or the community is the owner of the land.
my lord, either one.
Yes.
So page 41, my lord.
Page 41.
Yes. Annexure 16. Office memorandum by the PNER Nakul.
Mm.
Dated 3rd March 2023.
Mm.
Subject, filling up of Group D post. The present question is Group D.
Mm.
In the department, corrigendum issued regarding the procedure of filling up of grade 4 posts in the government has been laid down by memo such and such 17 and 24 to 318. So The later memorandum lays down that application for recruitment to the post should be called through open advertisement. That is normal. 2. Following difficulties expressed by various departments on account of the fact that in many cases, Group D posts, such as Chukidar, the present issue, Mali in views are filled by landowners. That is specific. Or on compassionate ground in locally in the districts, subdivision or village level. The matter was considered by the cabinet in its meeting held on 9 February 2022 in 22 February 2022. Then, in order to remove such difficulties, it is hereby directed that the condition of advertisement is dispensed with wherever such difficulties are faced by the department. So, in the present case, it is a landowner question. So, advertisement is dispensed with when landowner issue is faced by the department. That is the whole purpose. As long as here, my lord, intransparent eligibility criteria in process is followed, and in all such cases, approval of the government is obtained. So, for giving approval by the government have directed the DC to verify. So that is complete in case of the petitioner. Then, my lord, next, about the land ownership. This is written by the government of Nagaland. Social welfare, my lord. It's not the present particular department. To the ministry. How? About the term public land. As per the Constitution of India, Article 371A, special provision with respect to the state of Nagaland. Clarification regarding page 42, madam. Sir, I'm directed to refer to your letters and such and the subtitled above and furnish the interpretation of the term public land in Nagaland vis-a-vis Article 371A of the Constitution of India. The observation of the Land Revenue Department Government of Nagaland is reproduced below for your information and further necessary action. Land Revenue Department. The Land Revenue Department has examined the matter under reference and observed the following. 1. Nagaland have a peculiar land holding system from the rest of the country as safeguarded by the Article 371A of the Constitution of India. Land and its resources belongs to, my lord, it's not only land. Land with its resources belongs to the private individuals and community. Whenever necessary arises, the state government have to acquire the land as per the Nagaland Revenue and Land Acquisition in Acquisition Act 65 by paying land compensation to private landowners. Public. That is some of my law, which I stated in my para 9 at page 16 of my writ petition.
Okay, this is your case.
My lord,
Okay, okay. Yes. For the,
Yeah,
you are for state respondent,
Lordship, I'm for respondent number 127,
127, yes.
Lordship. Lordship. from the-
So, while the appointment of the respondent number 9 and 10
Lordship.
was made, at that time, this OM was holding the field.
Lordship.
This OM dated 3rd of March 2022 regarding filling up of the grade group D post in the department.
Lordship.
Okay.
Lordship, Lordship, in the affidavit in opposition, we have clearly stated that, Lordship, if we go by the MOU,
Pardon?
if we go by the MOU, Memorandum of Understanding, that was a memorandum of agreement dated 1972, Lordship. From the agreement, it appears, as Lordship is well aware, that a compensation was given to the landowner, Lordship. And moreover, Lordship, if Lordship may kindly come to the dear annexures, Lordship. Lordship may kindly come to page 26 of the requisition, Lordship. There. I will 26B. Lordship, this is the type copy. If Lordship may look at the right side, honors, witness as well as the honors. Honors, from here, one name appears, that is Mayam Tenjan, address Kensia village, Lordship. Lordship, from here it appears that Lordship, may kindly come to page 25, Lordship. Page 25. 25A. Here is stated memorandum of agreement met on 18th day of December 1972 between Sri Nungshan Miran, son of so and so, by occupation cultivator at present resident at Kensia, hereinafter referred to as the owner, Lordship. There is only one owner, Lordship. If we go by this agreement, Lordship. And Lordship, and the agreement was executed by, namely, this person, this incumbent only, Lordship. So, Lordship, we are not disputing to the fact that they are not a landowner. By the NOC and all, it appears that, and from the verification of the deputy commissioner, it appears they are also the landowners. We are not disputing to that. But however, if we go by the memorandum of agreement that was executed on 18 December 72, Lordship, from here it appears only one name appears. Had it been the subplan, Lordship, they should also have appended the signature, Lordship. That is only my case, Lordship. Because had they been the landowner, Lordship, they should have also have.
You are not disputing the verification report and the NOC given by the village council.
Lordship, we are not disputing because that is our own
Then the report of the deputy commissioner,
Lordship,
also not been disputed by you.
Not disputed by us, Lordship.
Then,
but we are not disputing to that. But here the agreement was only executed by one person, Lordship. So
then,
the question
the
question of subplan does not arise. When a person, when namely one Nungshan Marin who have executed the agreement between the government, between the state government as well as the who appears to be a sole landowner, Lordship. Lordship, basically that is my case, Lordship. So we are not disputing that they are not the landowners. In fact, they may be a landowner, but But however, Lordship, we have a notification, 5 March 2018, more particularly 3C, which clearly state that if Lordship may kindly come to that project, there is a policy of the government which clearly state that Lordship may kindly come to page 9, type copy of my affidavit, also, of our affidavit. Affidavit in opposition, respondent number 1 to 7.
Page number?
Page number 9. This is a type copy.
How many affidavits you have filed?
One. Affidavit in opposition on behalf of respondent number 1 to 7.
Dated?
Dated
6 of August 2025?
March 25. Fifth March 2. Page 8, page 9. Affidavit in opposition filed on behalf of respondent 1 to 7.
Page number?
Page number 9. This is a type copy.
Yes.
Notification dated 5 March 2018. More particularly 3C. 3C, if I may not read. It is also clarified that it is not the policy of the government to provide employment to the landowner in perpetuity. The employment of landowner, if permitted by a verifiable and valid agreement, is limited to the person first appointed as landowner in government service and does not entitle his descendants for further employment on his retirement from service. After the appointed landowner retires or vacates the post, the vacancy will be filled up through open advertisement in consonance with the existing policy, giving equal opportunity to all applicants. Lordship, here is the key.
No, that's all right, but whether there was any advertisement?
No.
Then?
No advertisement was.
Then?
But however, Lordship, one vacancy arose, Lordship. That vacancy, Lordship, that the incumbent who retires, that incumbent, initially he was posted and then he was posted in Dimapur and not in Mokokchung. Later on, he was transferred to Mokokchung, Lordship. And thereafter he retired, the incumbent retired from Mokokchung, Lordship. So the vacancy, now that the disputed vacancy, that was arose in Dimapur and not in Mokokchung, Lordship. So, Lordship, basing on the Lordship, the petitioner hearing, they are praying before this honorable court on land ownership, Lordship. However, there's vacancy that was arose in Dimapur, which we can which I have annexed in page.
No, that's all right.
Page
Now the
13,
question is whether you have followed this notification dated 5th of March 2018
Lordship.
or the OM of 2022. 2022, yes. You have not followed it
No.
in respect of appointment of the respondent number 9.
Respondent 910.
910.
One person.
Yes.
9.
So then how this notification you have relied upon will help you?
Lordship, regarding the 3C, Lordship, in fact, the landowner, I have annexed in my affidavit, Lordship, page 12, Lordship, annexed here, Lordship. this is a chart, appointment of grade 4 staff
Hmm.
and the assistant controller LMCP Mukokchung Lodge. Annexure D, where the name place at serial number 2 lodge.
Hmm.
Sri Toshiwamba.
Page number?
Page number 12.
Pardon?
Page number 12.
Of
Of
your
my affidavit.
Of your affidavit.
Lord. 1 and 2. 1 and 2. Serial number 1. Lordship has got. Page 12. Annexure D. This is a chart.
Yes.
Lordship. 1. Serial number 1.
Hmm.
Grade 4 staff under the establishment of the Office of the Assistant Controller LMCP Mokokchung. 1. Sri Rongsen Samba, post peon, and the appointment was made in the year 2016. Remark is from the extreme right, landowners Longchar clan, Kensa village, Mokokchung. Serial number 1 was appointed on landowner. Secondly, serial number 2, Sri Toshi Wabang was appointed as Chokidar, extreme right. Remark is landowner Longchar clan, Kensia village, Mukokchung. And appointment was made in the year 2018 Lordship. So that will be in contravention with the notification dated 5 March 2018 Lordship. Where the notifications clearly state that landowner should not be given perpetuity Lordship. Whereas the 2 landowner has already been appointed on land ownership basis.
No, they are of different clans.
Lordship, both are from Longchar clans. No. Both are Lordship from the extreme right. It appears that both are from Longchar clans. However,
is not Longchar.
The petitioner is of which clan? Petitioner?
Clan is Kichu, but there it is not the clan as a whole, it is a group of people.
Hmm.
One is Takachojang, which is from Longchang. And Your Lordship may kindly see not my own submission, but the verification given by the EAC. Page 36 is clear. Page 36. I may be allowed to repeat. Upon verification, it has been learned that the land occupied by certain sites, Mokokchung region belongs to 3 subclans, namely from Takachujang, that is 1. 2 is Mokok Sangpa. 3rd is Nikan, which is the petitioner. This land was purchased by the government in the year 1932. Accordingly, an agreement was signed with the landowners, which is endorsed. Includes for your reference. It has also been verified that the applicant, Mount Sanapao, is a genuine landowner belonging to Nikan Manor. That is the verification by the administration. Manor.
Lordship, but however, from the extreme right, Lordship, it appears that the landowners are from the Longchar clans. From the extreme right.
Longchar clan, who had prepared this cert?
By the department.
Where is the seal and signature of the department?
Lordship. This is the chart which was prepared by the department. Lordship.
Show me where is the seal and signature of the issuing authority.
Lordship, signature is nothing.
Seal is,
Lordship.
whether seal is there.
My lord, may
No,
It's just
let
your
him,
logic.
let him
Yes.
complete. Let him complete. You can answer later.
Lordship. Lordship, since I'm representing the state, Lordship, this is the instruction that I received, and accordingly we have peer our affidavit. Lordship.
No, you show me from this document that this document was prepared by the department.
Lordship, this is the instruction that I received from the department, Lordship. Accordingly, Lordship, I have prepared, Lordship.
Whose report is to be, no, you see,
The memorandum of agreement, Lordship. Lordship, from the face of the report, it clearly appeared that only the signature which they appended on 1972, Lordship, one Mayang Temchen from King 7H. Nowhere it's mentioned that it's a sub-clans. Nowhere it is mentioned about that. And whereas in the condition also.
You see, you are not disputing the report of the deputy commissioner.
Lordship, we are not disputing that, but Lordship may kindly come to the memorandum of agreement that was executed between the owner.
No, we have already seen it.
Lordship, from here it's clear.
Only one name is there. Name of one person is there only.
Lordship. And in the condition also, it's clearly stated that the government has given all facility to the landowners. One, posts such as ministerial staff, contract work, be allotted without inviting tender.
You see, if the land belongs to the community and if there are 3 sub-clans in that community, whether all the 3 clans are not entitled, sub-clans are not entitled to the same benefit? Okay, forget about land ownership. This the notice you have notification dated 5th of March 2018.
Lordship.
Here it is stated that there must be advertisement for filling up of any vacant post.
Lordship.
And there is also the office memorandum of 2022. You have not followed it.
We have not found.
Then can we appeal the appointment of the respondent number 9?
To that extent, I leave it, Lordship.
No, you tell me whether the appointment of the respondent number 9 is legal. Can it pass the legal scrutiny?
Lordship,
in view of the notification which is part of your affidavit and in view of the office memorandum of 2022 which is enclosed by the counsel for the petitioner, can we say that your appointment is legal?
Lordship, we have received the application from the.
No, that's all right. That is not the procedure prescribed in the notification and in the OM.
Lordship, accordingly, application was received and then approval was issued, Lordship, by the government.
Maybe.
On that, Lordship.
You are violating your own notification and OM.
Lordship.
Anyway, who is for respondent number 9? You. Yes.
I'll take your lordship to my affidavit and
Yes.
position. I'll just take your lordships to 3 paragraphs, specific paragraph.
Paragraph number?
3, 4, and 13. If I may read, your lordship. That with regard,
Now, one thing, Your Lordship, the petitioner is not disputing that two landowners have already been appointed.
Mm.
The only case is that one sub-clan has not been appointed
Mhm.
so far. That is their clan, that is
Mm.
their case, but
Mm.
I'll take Your Lordship to the paragraph. 3. That with regard to the statement made in paragraph 2 of the petition, the deponent respectfully states that the policy regarding appointments on land ownership basis is governed by notification number so and so, dated 5/3/2018. Clause 3C of the said notification makes it clear
Mm.
that the employment of landowner, if permitted by a verifiable and valid agreement,
Mm.
is limited to the person first appointed as landowner to government service and does not entitle his descendants for further employment on his retirement. From the MOU dated 18/12/1972, it is ascertained that the compensation of so and so at a rate of rupees 2,000 per acre was paid to the landowners for the right in question. In the instant case, contrary to the notification dated 5/3/2018, the landowners have already availed 2 appointments on land ownership, which fact may be ascertained from the list of grade 4 staff under the establishment of the Office of the Assistant Controller LMCB Mokokchung.
Mm.
The incumbents at serial number 1 and 2 of the said list, namely Shri Gongsan Sangba Beyond, appointed on 21/6/2016, and Shri Tushiwabang Chokidar, appointed on 4/9/2018, are the landowner appointees. Thus, as per the standing policy, the landowners have exhausted their right to appointment on land ownership basis. In fact, the landowners have been appointed in excess of the single appointment policy laid down in the notification. This being the position, the petitioner has no locus standi to claim the right of appointment on land ownership against the post to which the deponent has been appointed. That is with regard to land ownership, whether he has a right to be considered under land ownership or not. So 2 appointments have already been made, and as the learned government advocate has pointed out, the agreement is signed by an individual.
Mm.
So far as claim on land ownership is concerned, it is to be based only on the agreement.
Mm.
It cannot have addition subsequently by way of inquiries and all those things. The agreements itself, who signed it?
Mm.
The landowner, who was at that point of time, who claimed to be the landowner and nobody objected,
Mm.
he has signed a memorandum of agreement. Now, if today one person comes and says that I'm a sub-clan of this, because they all belong to the same clan. Now they are saying that there were 3 sub-clans. Subsequently, another person will come and claim that there is another sub-clan. Your Lordship. So the agreement itself must be read as it is and no addition should be made. So now here, landowners too have already been appointed. The petitioner, though he is a landowner, he belongs to that clan, and now he is claiming that he is a sub-clan member of that clan.
No.
So
his claim is supported by the inquiry conducted by the
yes.
This as an extra assistant commissioner.
Your Lordship, even after that also, then the position is that only one appointment can be made.
Mm.
As per the memorandum, only one appointment. Sub-clans and clans and all those cannot go on making claims. It will never exhaust. So the memorandum, the office memorandum of 2018 makes it very clear that only one appointment, land ownership. Even if it is an agreement, henceforth only one appointment can be made. Subsequent to this, the second appointment was made of the landowner. Now the landowner's quota has exhausted. So far as that is concerned, so far as the right on land ownership is concerned, they cannot go on claiming on the basis of clans, sub-clans, and so on. Memorandum has to be read as it is. Landowner has only one right to be appointed. That is my position. So here, landowners have now exhausted their claim. So the petitioner, so far as on the question of locus standi, as to whether he is a landowner having the right to be appointed or not, no. He has no locus standi with regard to land ownership, appointment on land ownership basis. When the
No, that's all right.
Yeah. Now-
Where is
Yes.
that finding of the authority, appointing authority?
yes, appointing authority, they may make these submissions,
Hmm.
but it has to be on the, ultimately decision has to be made on the basis of the memorandum,
Hmm.
standing memorandum.
No, where is the finding of the appointing authority that the claim of the petitioner for being appointed as this watchman cannot be made as the quota belonging to the landowners already exhausted? Where is that finding?
The question of your lordship, I am basing only on the memorandum. Memorandum says that landowner has only one appointment.
Hmm.
They are entitled to only one appointment. Your lordship will see.
No, that's all right.
Yes.
But
So
to
now-
that effect,
Yes, when the landowner.
no.
Yes.
since the petitioner has filed an application for being appointed
Yes.
in Group D post,
Yes.
is it not necessary for the department to pass an order to that effect that the quota of landowners is already exhausted? So the petitioner cannot be appointed. Where is that finding?
Your lordship, they are not disputing that two landowners have been appointed already.
Pardon?
To the issue of the fact that two landowners have already been accommodated is
No.
not disputed, your lordship.
You say
Yeah.
there was only one post. Two
Yes.
person applied, you and the petitioner.
Yes.
Claim of the petitioner was rejected. What is the ground of rejection?
Yes, that only the government knows, your lordship. I am the respondent.
No,
I am
that's
the
all right.
Respondent, yes, so only the
That's
government
all
will
right.
be able to justify that, your lordship.
Yes.
But
Now forget about his claim
Yes,
on the basis of land ownership.
yes.
Now you justify your appointment in
Yes,
view of
sure.
the notification.
Now, the petitioner has made no specific allegations, nor any prayer in the petition for my appointment to be quashed and set aside, besides on the basis of land ownership. Now, here, I would like to place a judgment of the Honorable Supreme Court. When the petitioner has himself not made any specific prayer for quashing only besides only on the ground of land ownership,
Hmm.
whether under Article 226.
Maybe
Lordship,
since this petition is under Article 226,
226. That is why
this court has the power to move the relief
So,
being sought for.
on that ground, I would like to place a judgment. Your lordship may just go have a look at the judgment.
Hmm.
I'll take your lordship to specific paragraph.
Hmm.
2010.
Where is?
2010 1 SCC, your lordship.
Yes.
SCC 234.
Hmm.
Paragraph 29 to 33, your lordship. Page 246.
Yes.
If I may read, your lordship. Paragraph 29.
Hmm.
The approach of the High Court in granting relief not prayed for cannot be approved by this court. Every petition under Article 226 of the Constitution must contain a relief clause. Whenever the petitioner is entitled to or is claiming more than one relief, he must pray for all the relief.
Your appointment is being challenged in this petition.
Yes, it is being challenged, but on the ground that landowner was not. It is a post meant for the landowner should be considered. Only on that ground, your lordship. That is the only ground which has been taken in the petition. No other ground. So here I am saying that if he fails on that ground, then now he cannot bring in new grounds. That is my case. That is my humble. Yes, subsequently they may file another writ petition, but not by way of this writ petition. In this writ petition, only one ground. That is, it is meant for landowner should be considered.
Mm.
Now, if it fails, then on other grounds, it cannot be. That is what I am trying to project before the law.
Mm.
So it is very clear here in this. Every petition under Article 226 of the Constitution must contain a relief clause whenever the petitioner is entitled to or is claiming more than one relief. He must pray for all the reliefs under the provisions of the Code of Civil Procedure.
No. Here the only relief is for quashing your petition.
Petition
sorry, quashing your appointment.
And considering
His candidacy.
case
Yes.
for appointment on land ownership.
Mm.
Now, if it fails, if he has no right to be considered for land ownership,
Mm.
Your Lordship, there has been so many cases brought before this honorable court.
Mm.
In another case, in a similar case, where the landowners claimed only for considering his case, and this court found that he was not entitled since landowners have already been appointed. The court dismissed the petition. And this is one such case. If Your Lordship may have a I'll take your paragraph 15, Your Lordship. Paragraph 15 onwards. Paragraph 15 and then 18. I'll take Your Lordship. 15. In view of the condition at clause 3C of the notification dated 5th March 2018, state respondents cannot appoint more than one landowner. It is therefore stated that the petitioner has not made out a case for the interference of this court, and the petition may be dismissed. Now, 18. It is an admitted fact that the petitioner belongs to the clan of the landowners. Hence, in the present case, there is no requirement of referring the matter to the deputy commissioner of the district, as the department concerned, that is respondent number 2 and 3, have already admitted from their letters dated 6 January 2020 and 22nd January 2020 that the petitioner is a landowner. However, at clause 3C of the notification dated 5th March 2018, it is categorically provided that it is not the policy of the government to provide employment to the landowners in perpetuity. The employment of landowners, if permitted by a valid agreement, is limited to the present first appointment as landowners in government service and does not entitle his descendants for further employment on his retirement from service. It is also provided that after the appointed landowners retires or vacates a post, vacancy shall be filled up through open advertisement in consonance with the existing policy, giving equal opportunity to all applicants. The notification dated 5th March 2018 does not provide for appointment to all the descendants of different forefathers of landowners. The notification speaks only of one person to be appointed as landowner. In the present case, it is not disputed that one Shri Guna Sangwa has already been appointed as a landowner in the post of scale man in the office of the respondent number 3. Therefore, the right of the present petitioner, if any, has been extinguished by the appointment of Shri Guna Sangwa on the basis of land ownership. As the petitioner cannot claim as a matter of right that he should be appointed against the vacant post of scale man in the office of the respondent number 3, he has no locus standi to challenge the appointment of the respondent number 4. So here, his claim is that vacancy was meant for landownership appointment. And so my appointment should be cancelled and his should be considered. That is the only case he's bringing forth before this court in the writ petition. No other grounds are taken. So if he fails on this ground that he is a landowner, his right is extinguished by the appointment of the 2 other persons, then he has no locus standi in the present case, and his case should be dismissed. That is my humble submission before this. And so far as
no, you see whether this Article 16 of the Constitution of India is not violated here for being appointed you without following due process of law.
I am not going into that, Your Lordship. Yes, I have to admit before your lordship, no selection process was.
Yes.
The government gave approval for my appointment. Accordingly, I was appointed. I was appointed accordingly. And whether rightly or wrongly, I was appointed. It is the government which has given me the appointment. But like your lordship is raising, yes, no selection process was conducted. I have to admit that I cannot go around that issue. But my only case is that, yes, he may also challenge it, but in this writ petition, he has not done. He has not. His only case is with regard
he has
to-
also enclosed the office
He has,
memorandum.
yes, he has enclosed, no doubt. But in the petition itself, the sole petition itself, if your lordship will read it, it is solely on the ground that the only ground taken is that the landowner alone should be considered. If that issue fails, if his right to challenge it on the basis of land ownership fails, my case, your lordship, then in that case, yes, subsequently he may file another writ petition challenging my appointment. He has every right to do that for pushing and setting aside and asking this honorable court to direct the state respondents to advertise the vote so that he also and other eligible candidates also get a right. And he may always do that. I am not saying that it is, but so far as this writ petition is concerned, since the only ground he has taken fails, he has no right as a landowner. On that ground alone, the case matter should be considered. That is my humble submission before this honorable court. Not go into other areas other grounds which he has not taken. That is my only. That is my. And secondly, your lordship, that other paragraph which I was reading, your lordship, paragraph 4 also. Paragraph 4 also.
Paragraph 4 of?
Paragraph 4 of my affidavit, I have taken, at the outset, I have informed your lordship that I would be going to 3 paragraphs. So, first paragraph, with regard to the notification is concerned, land ownership right is concerned. Second one is paragraph 4. That with regard to the statement made in paragraph 3 of the petition, the deponent respectfully states that Tushiwama, watchman Gang Chokidar, who retired on superannuation, was initially appointed by order white number so dated 17/8/1988 and posted at Dimapur in the office of the Assistant Controller of Weights and Measures and was subsequently transferred to Mokokchung by an order dated 16/8/1991. Details of which may be ascertained from Annexure P herein above at serial number 5. Essentially, therefore, the post held by him is one belonging to the office of the Assistant Controller of Weights and Measures, Dimapur, and deemed to be treated as a vacancy arising at Dimapur upon his retirement. Hence, even assuming but not admitting that the landowners are yet to be appointed in terms of the provisions of the notification, dated 5/3/2018, they cannot be considered for appointment on land ownership basis against the post which arose at Dimapur. So this is a post at Dimapur actually. The post vacancy, but then the incumbent subsequently got transferred. He can always go back.
Transferred means
That-
transferred with the post or without the post?
Your lordship, he was only transferred. That is
No,
what-
without the post, can it be made?
Your lordship will see the appointment order also. I have annexed in the appointment order. So we don't know what is going on. I have no idea.
You see,
Yes, I have no
when
idea.
a person is transferred from one place to another
Yes.
place, there must be post to the at the place where
Yes.
he has been transferred.
Yes.
So if he has been transferred to Mukhoksang without any post, is it permissible?
He carried his post along with him, but
Yes.
he can always go back to it is up to the government. I
No,
don't have
in
any
that
say
case,
in that.
the government has to again withdraw the post from that place to the original
Yes,
place.
that is why in the.
Is there any order?
Your
to
lordship,
that-
the appointment order itself, your lordship, it is, your lordship, I'll have to take your lordship to the appointment order, which is the writ petition. Because only the record will speak. Beyond the record, I cannot say anything. It would be presumptuous on my part to bring things which are not there in the record. So here, in the appointment, there are two appointments, two orders, Your Lordship, which are. So page 39. Page 39. Consequent upon the approval of government white letter number so and so dated 13/12/2023. The undermentioned is hereby appointed as watchman cum chowkidar in the office of the Controller of Legal Metrology and Consumer Protection, Nagaland, Kohima, in pay level 1 of the pay matrix, plus all other allowances as are admissible under the rules in force from time to time with effect from the date of taking over charge. So here, no specific appointment at a particular post place is mentioned, Your Lordship. Legal Metrology and Consumer Protection, Nagaland, Kohima. So he's appointed, then she's. Then by the next order, upon approval of the government in the interest of public service, is a Srimati Kosangla is hereby appointed to the post of watchman cum chowkidar in the office of the Controller of Legal Metrology and Consumer Protection, Nagaland, Kohima, and posted in the office of the Assistant Controller of Legal Metrology and Consumer Protection, Dimapur. This is the only thing which I have. I have received only these two copies. These are the copies. So I am only taking Your Lordship to the reports. But my case humbly before this honorable court is that when the petitioner has done that, and the last one, that is paragraph 13. This is with regard to the point which I have been stressing on. Paragraph 13. Page 7. That if I may read, Your Lordship.
Yes.
That the deponent respectfully states and submits that the sole ground taken by the petitioner in the instant case is that by virtue of him being a bona fide landowner candidate, his case for appointment is liable to be considered by the state respondents. But the record is clear that he has no standing to claim such right in the light of the facts. Firstly, that the post in question is one meant for the office of the Controller LM and CB Dimapur. And secondly, that even assuming, but not admitting, that the post is one meant for the Mohokchong office, the landowners have already availed appointment in excess of the one-time appointment policy laid down in a notification dated 5/3/2018. As such, the petition is liable to be dismissed. That is my only. Those are the three paragraphs I am referring. And the judgment of this honorable two court single bench, and then the Supreme Court case that when the counsel for the learned counsel for the petitioner has not brought grounds before this honorable court on this honorable court, though it has the power to grant relief according to the, but when there is no specific ground laid down, then on grounds which are not there in the petition, decision should not be made.
Okay.
That is the only ground I have. Your Lord.
Okay.
And I leave it to your Lord.
Okay. Yes. So what is your reply?
My learned friend, the government side, clearly submitted about their notification dated 5th March 2018. They are admitting about 18 December 1972 agreement. My Lord, I may be allowed to read out. Page 8 of my learned friend government side, respondent 107, notification dated 5th March 2018. This is also a part of a private respondent notification. 1A, my Lord, I may be allowed to read.
Yes.
a response laid down by notification such and such that no land, that is 2005, no land shall be acquired free of cost, and all land shall be acquired on payment of full compensation as determined by law. So 1972 agreement is not touched by this. 2005. No further condition of employment in service or contractual work should be entertained. All right. Therefore, in case of any department has entered into any agreement with the landowners, so this is very clear. Therefore, in case any department has entered into any agreement with the landowners in deviation of the laid down policy on or after 26/7/2005, it doesn't touch 72. Such, even just say that our agreement is after 2005. If it is given that contractual whatnot other conditions are to be attached, such agreement, my lord, shall be treated as null and void. Right. What is to be done? The department concerned shall take necessary action accordingly to nullify such agreement. So 75, 72 agreement is not nullified. 2005, the government came up with the policy that only an outright purchase without any condition of appointment. So this 3 March 2018 is not applicable in the present case, number one. Even if it is to be nullified, then the department concerned shall take necessary action accordingly to nullify such agreement. Yes, it is not been done. Then, as your lordship has clearly pointed out, 3rd March 2022 doesn't speak about it. It'll be the landowners. So it is dispensed with. Even for the advertisement by the 3rd March 2022, this is a cabinet decision.
No, but the question is whether you have made any averment to that effect in your petition.
My lord, 2018 being not applicable in the present case, I have not made any statement to that effect. Only 2022 will be applicable, which is a cabinet decision, my lord. That is my whole submission. Whatever it is, respondent number 9 or 10, appointment cannot be sustained in any view of the matter. Whereas the petitioner, full verification has been done. Justification placed before the department in cabinet decision justify his claim. That is my whole issue. It is not my own creation. Verification by the administration. Cabinet decision as per 2022, 3rd March 2022. Fully justify the petitioner case. Much obliged.
Okay. Heard, Mr. I Long, sir.
INTI.
IMT Long, sir. Learned counsel for the petitioner. Mr. V. Jimomi, learned government advocate for the state respondent number
127.
127. Mr. Learned counsel for the respondent number 9.
Nine is 10.
9/10.
9/10.
10.
Your Lordship, I'm appearing for respondent number 11.
That is village council. I made them a party respondent.
Okay. And Miss, your good name, please.
Good morning.
Learned counsel for the respondent number 11. 11. Argument concluded, judgment reserved.
Much of what?